Hello everyone and welcome back to Law Statistics. Today's presentation is based on Muslim Law Part 7th, Inheritance and Succession. Heritable property is that property which is available to the legal heirs for inheritance. After the death of a Muslim, his properties are utilized for the payment of funeral expenses, debts and legacies, that is wills if any. After these payments, the remaining property is called heritable property. Under Muslim law, every kind of property may be a heritable property. For purposes of inheritance, Muslim law does not make any distinction between corpus and usufruct, or between movable or immovable, or corporeal or incorporeal property. Under English law, there is some difference in the inheritance of movable and immovable property. But under Muslim law, there is no such distinction. Any property which was in the ownership of the deceased at the moment of his death may be the subject matter of inheritance. Moving ahead, joint or ancestral property. The concept of a joint family or of co-partneries property, as is recognized under Hindu law, is not known to Muslims. Whenever a Muslim dies, his property devolves on his heirs in definite share, of which each heir becomes an absolute owner. Subsequently, upon the death of such heir, the properties are again inherited by his legal heirs, and this process continues. Thus, unlike Hindu law, there is no provision for any ancestral or joint family property. Accordingly, under Muslim law of inheritance, no distinction has been made between self-acquired and ancestral property. All properties, whether acquired by a Muslim himself or inherited by his ancestor, are regarded as an individual property and may be inherited by his legal heirs. No birthright. Inheritance opens only after the death of a Muslim. No person may be an heir of a living person. Nemost. Therefore, unless a person dies, his heirs have no interest in his properties. Unlike Hindu law, the Muslim law of inheritance does not recognize the concept of right of birth. Under Muslim law, an heir does not possess any right at all before the death of an ancestor. It is only the death of a Muslim which gives the right of inheritance to his legal heir. As a matter of fact, unless a person dies, his relatives are not his legal heirs. They are simply his heir apparent and have merely a chance of succession. If such an heir apparent survives a Muslim, he becomes his legal heir and the right of inheritance accrues to him. If the heir apparent does not survive a Muslim, he cannot be regarded as an heir and has no right to inherit the property. Doctrine of representation. But Muslim law does not recognize the doctrine of representation. Under Muslim law, the nearer excludes the remoter. Accordingly, in the illustration given below, E will be totally excluded from inheriting the properties of P, both under Shia as well as under Sunni law. E has no right to inherit the properties of P. The result is that E cannot take the plea that he represents his predeceased father, B, and should be substituted in his place. Under Muslim law, the nearer heir totally excludes the remoter heir from inheritance. That is to say that if there are two heirs who claim inheritance from a common ancestor, the heir who is nearer to the deceased would exclude the heir who is remoter. Thus, between A and E, A will totally exclude E because A is nearer to P in degree, whereas E belongs to the second degree of generation. Per capita and per stripes distribution. Succession among the heirs of the same class but belonging to different branches may either by per capita or per strips. In a per capita distribution, the succession is according to the number of heirs. Among them, the estate is equally divided. Therefore, each heir gets equal quantity of property from the heritable assets of the deceased. On the other hand, in a per strip distribution, the several heirs who belong to different branches get their share only from that property which is available to the branch to which they belong. In other words, in the stripital succession, the quantum of property available to each heir depends on the property available to his branch rather than the number of all the heirs. Per capita and per stripes distribution, M has got two sons, A and B. A has three sons, S1, S2 and S3. B has two sons, S4 and S5. When M dies, there are two branches of succession, one of A and the other of B. Suppose A and B both die before the death of M, so that the sole surviving heirs of M are his five grandsons. Now, under the per capita scheme of distribution, as recognized under Sunni law, the total number of claimants, heirs, is 5 and the heritable property would be equally divided among all of them irrespective of the branch to which an heir belongs. Therefore, each of them would get one fifth of the total assets of M. Female rights of inheritance. Males and females have equal rights of inheritance upon the death of a Muslim. If his heirs include also the females, then male and female heirs inherit the property simultaneously. Males have no preferential right of the inheritance over the females, but normally the share of a male is double the share of a female. In other words, although there is no difference between male and female here, insofar as the respective rights of inheritance is concerned, but generally the quantum of property inherited by a female here is half of the property given to a male of equal status. The principle that normally the share of a male is double the share of a female has some jurisdiction. A child in the womb. A child in the womb of its mother is competent to inherit provided it is born alive. A child's embryo is regarded as a living person and as such the person vests immediately in that person. But if such a child in the womb is not born alive, the share already vested in it delivered and it is presumed as if there was no such heir at all. Now is the primogeniture. Primogeniture is a principle of inheritance under which the elder of the deceased enjoys certain special privileges. Muslim law does not recognize the rule of primogeniture and all sons are treated equally. However, under the Shia law, the eldest son has an exclusive right to inherit his father's garments, sword, ring, and the copy of Quran, provided that such eldest son is of sound mind and the father has left certain other properties besides these articles. Now is the stepchildren. The stepchildren are not entitled to inherit the properties of their stepparents. Similarly, the stepparents too do not inherit from stepchildren. For example, where a Muslim H marries a widow W having a son from her previous husband, the son is a stepson of H, who is stepfather of the son. The stepfather and the stepson cannot inherit each other's properties. That stepchild is competent to inherit from its natural father or natural mother. Similarly, the natural father and natural mother can inherit from their natural son or daughters. However, the stepbrothers can inherit each other's properties. Thus, in the illustration given above, if a son is born out of the marriage of H and W, the newly born child would be a stepbrother of the son from wife's previous husband. Now is the simultaneous death of the heirs. When two or more persons die in such a circumstance that it is not ascertainable as to who died first, then both of them cease to be an heir for each other. In other words, where two or more heirs die simultaneously and it is not possible to establish as to who died first, then under Muslim law, all the heirs are presumed to have died just one moment. The result is that such heirs are regarded as if they did not exist at all. The inheritance opens omitting these heirs. Missing persons. According to the text of Hanafi law, a missing person was supposed to have been dead only after 90 years from the death of his birth. Till then, the inheritance of his properties did not open. But now this rule has been superseded by Section 108 of the Indian Evidence Act of 1872, which provide as under: when the question is whether a man is alive or dead, and it is proved that it has not been heard of for 7 years by those who would naturally have heard of him if he had been alive, the burden of proving that he is alive is shifted to the person who affirms it. Accordingly, where a Muslim is missing for at least 7 years, and if it could not be proved that he or she was alive, then that person is legally presumed to be dead and the inheritance of his or her properties opens. Now is the escheat. Where a deceased Muslim has no legal heir under Muslim law, his properties are inherited by government through the process of escheat. State is regarded as the ultimate heir of every deceased. Marriage under Special Marriage Act. Where a Muslim contracts his marriage under the Special Marriage Act of 1954, he ceases to be a Muslim for purposes of inheritance. Accordingly, after the death of such a Muslim, his or her properties does not dissolve under Muslim law of inheritance. Dissolution of Muslim marriage. The act was passed in 1939 to enable a Muslim married woman to get a divorce decree by filing suit against her husband. As earlier, there was no such law to enable wife to get a degree except for importunity of husband or imputation of unchastity to wife by her husband. The act became operative from 17th March 1939. Moving ahead. Apostasy. Before this act, apostasy from Islam dissolved the marriage, but Section 4 of this provided that earlier renunciation of Muslim Islam on conversion to any other religion by the wife will not ipso facto dissolve the marriage. However, apostasy of the Muslim husband operates as a complete and immediate dissolution of marriage. It provided for the following grounds to the wife: husband whereabouts unknown for above 4 years, husband failure to maintain his wife for 2 years, impotency of the husband, his insanity, his cruelty, imprisonment of husband for 7 years, failure to observe marital obligations, any other ground recognized by Muslim law. Grounds explained. Unheard if husband is unheard of 4 years or more, his wife may file a suit and get a decree. This comes into operation after 6 months and marriage get dissolved. If the husband within the 6 months presents himself and agrees to fulfill marital responsibilities, the court may dissolve the marriage. Maintenance. If the husband fails to maintain his wife for 2 years or more, the wife may file a suit. If for a reasonable cause the wife is living separately for 2 years, the court may give a decree. Moving ahead. Grounds explained. Insanity. If the husband is suffering from insanity, leprosy, or venereal disease, the wife may get a decree. The duration is not fixed by the act, the court decides. Cruelty. This is another ground. It may be physical or mental. Attributing unchastity and scolding again and again with vulgar language is mental cruelty. The court decided what is cruelty. Now is the imprisonment. If the husband is convicted for 7 years or more and confirmed by the highest appellate court, the wife may claim degree. And the marital duties. If the husband for 3 years has not fulfilled the duties, the wife can file a suit. That's all for the presentation. Thank you and have a great day ahead.